right. Good afternoon. Welcome to CAI New England's first ever podcast. We're going to call it the Property Playbook. I'm ecstatic to be joined today by no stranger to CAI New England, my friend Tom Moriarty. Tom, welcome.
Thank you, Patrick. Happy to be here. Happy to
Yeah,
be
it
your
was
first and hopefully not a terrible guinea pig on this first launch.
no, it should be good. It was good seeing you a few weeks back. I was able to see you at the awards night, and happy to be able to give you your award for the Hall of Fame, which was certainly well deserved. So again, congratulations on that.
Well, thank you, sir. Thank you.
When we were kicking around this idea for a podcast, we started looking at topics, and I think one of these topics that came up was fees being charged by associations. What can they charge? What can't they charge? And it seemed to be somewhat relevant at the time, maybe not as relevant now, but that's my opinion. But there's other things that have come up since then. But I know you were kind of right in the thick of things at that point, so we decided we'd have you on to discuss that. Like, what can associations charge? What can't they? Like, we know that by virtue of the docs that they have, boards have, extreme latitude in terms of managing and maintaining associations, right? And there's always that within reason, right? Within reason. So what are your thoughts on that?
Always. Yeah, so it's actually a very, very nuanced area, and it's got some complexities that can create some traps for the unwary. So you're right to think, well, the boards have substantial discretion with regard to how they operate the associations. They operate within, the strictures that are provided by the governing documents, but they also always have to act consistently with the statute, right? So the governing documents really can't authorize a board to do that which the statute prohibits or limits. So where the fees kind of become relevant and potentially dangerous is where the fee is not specifically authorized by the statute. So we know that many fees are specifically authorized by statute. So you take like a late fee. The statute specifically authorizes a board to charge a late fee. So that's within the scope of what the board can do. But the statute creates some conflict with regard to the ability of a board to simply charge whatever it wants, because the statute has a provision at Section 6A1 that most managers and trustees are familiar with, that dictates how a board can assess common expenses. So the statute says common expenses have to be assessed according to respective percentage of beneficial interest, or where the documents allow square footage. So there is a fundamental question about whether and to what extent a fee being charged could potentially be characterized as a common expense. If it's a common expense, it's got to be assessed as a percentage interest allocated to all or among all the unit owners. And if not, it can be charged as a fee to an individual. So that's kind of where the friction exists.
Gotcha. And where I see this comes up a lot, and we've had this discussion before, is these other fees, whether it be fines for rules violations, or resale certificate fees, or any other fee they want to charge, key fee, pool permit fee, what makes it a pool permit. So outside of that, like, these aren't typically outlined in the documents, right? Every specific thing.
Right. That's right. Yeah. So you'll find that in a policy or a rule and regulation that's adopted by the board. And I would say there's a hierarchy in terms of defending a fee that's being charged. Kind of put aside the question for a moment of whether it's authorized or whether it's reasonable or what considerations the board should have. If you just kind of think about it as a hierarchy, if it's in the statute, as I said already, the board can feel pretty comfortable that the fee itself, right, the concept of a fee for X is defensible. If it's in the governing documents, that then provides the basis for the board to claim that it has, a standard or an objective basis to assert a fee in a particular circumstance. And if it's in the governing documents, the additional benefit there is that a board can say, look, everybody's on notice. These are recorded instruments. Everybody knows about it. So people, unit owners know what they're buying into when they acquire a unit. And then the other way you could find a fee, or place you might find a fee, is in a policy or rule and regulation. Now, those can be changed by the board unilaterally. So, and they don't have to be recorded. So if they are recorded, you'd still have the argument, well, everybody was on notice of it. But rules and regs that can be changed at the whim, quite frankly, of the board. There's a new board, maybe there's a new set of rules. Those have probably the least heft in terms of defensibility with regard to notice, because they can be changed. So if you were looking at the hierarchy, you'd say, absolutely defensible, authorized by statute. In the governing documents, your only check probably there is, does it violate the statute? And then the next is the rules and regulations, ones that are recorded, more valuable probably than ones that are not recorded, just because there will be an argument, or could be an argument, for someone to say, I didn't know about it.
True. So why would a board consider charging a fee as opposed to simply paying the cost out of operating, and therefore the fee is essentially charged back to everyone anyway, right? By virtue of it would be in your budget, right?
Yeah, and then I suppose less risk. But yeah, but the reason that a board would consider this, I think, is probably where there's some desire to impose upon some number, less than all of the unit owners, a particular charge, right? So if you think about it in the context where a board might charge a fee that is designed to dissuade certain activity or behaviors, right? You could characterize it as a fine, but there could be a fee associated with X because you want to dissuade the activity. There also could be a fee that statutorily should be attributed to that one individual. So there was some investment of time or energy or cost. The statute says you can do it, and it's appropriate to then allocate that cost to that individual so that their neighbors are not sharing in the cost. But then there are also circumstances where, in fairness, a board might say, well, there's someone who is going to benefit from the common area right now. Let's say it's associated with exclusively occupying the clubhouse because they're going to have an event there, right? So something that the unit owners get to do, they have a right to do, but they can't just go in and do it in every circumstance. And when they do it, other unit owners can't. So the board might say, well, there's going to be a fee associated with that because that unit owner is now occupying common space for its benefit exclusively. And there may be a cost associated with that, which is not really a cost that the association would normally incur in connection with, administrative expense or management, repair, maintenance, placement. So the board would say, well, in those instances, geez, it would be fair for someone to pay a fee because otherwise Doe could be reserving the conference room every day, all day, to the exclusion of the other 400 owners. So a fee there would seem, appropriate. So there are practical reasons that a board might want to adopt a fee because they can't achieve the same goal by just treating it as a general common assessment.
Yeah, those are all great points. And typically we see those, right? And those are the fees. I think where boards and associations get into trouble is when they're trying to use these fees to balance their budget, if you will, right? We might do, I've had boards that say, well, we used to do $5,000 in fines a year and you didn't budget anything. Like, well, you shouldn't really be budgeting to fine people $5,000. If you get it, great. And it's there, again, it's there to curtail a certain behavior, right? Especially for fines. But in these other instances, what then makes it become something where a board, because we always get the question is, well, what is reasonable and what isn't reasonable? Like, can we charge 10x? And it's like, well, I would, I guess depending on the situation, right? I don't know if that would be a reasonable fee to rent the clubhouse if they could go down the street and rent a hall for a fraction of that, right?
Right. Yeah. So the unfortunate reality is that in the law, reasonable or reasonableness is applied in many, many contexts. And you could say, like beauty, it is in the eye of the beholder, or in many circumstances, the eye of the judge or the jury. So it's impossible to provide an equation, but there are certain things that a board can think about in terms of reasonableness, right? If the board is trying to dissuade a particular behavior, not paying the common area expense fee on time. So say there's a late fee associated with that. So the common area expense fee, just make up, it's $500, right? So there's an adverse impact to the association associated with a failure to pay that. So would it be fair to charge $10,000 as an easy example? Well, as a consequence of not paying your $500 common area expense fee, no, any court in the world is going to throw that out. Is the board stuck charging $1? That's easy. Probably not. There are objective standards that the board could use. What would the interest rate be at a particular time? Although it does not have to be tied to interest rate. It can be a fee. And there's also some type of punitive effect to it too. It's not just the loss of the use of the money. It's imposing upon the owner some penalty so that they're less inclined to do it in the future. So a 10% charge as a late fee, I think that's in the realm. I mean, could a court tweak it? Yeah, if it was 100%, if you were charging 500 on a $500 a month fee, I think that's probably unreasonable. But you really do have to exercise some common sense and judgment in the circumstance. If you think it's a little too aggressive, you can talk to your manager. What are other associations doing? What's worked in another association? If you have some empirical support for the reason you picked a particular number, it's going to help. Talk to the lawyer. The lawyer may have had experiences where fees have been rejected, because they were unreasonable. So there are ways to try to identify, but a lot of times it's employing some good old-fashioned common sense.
Well, yeah, that's the name of the game every day, right? Unfortunately, we don't get there all the time. So, one of the things, and this is from Massachusetts only, because the laws in other states are a little bit different, and I'm noticing it even more down in Rhode Island, that it's really like bizarro world in terms of what's in the statute and what's not, and how things are tied to it. But I guess where is the biggest fee that you see, that you've seen, where there's been the biggest amount of, because a lot of it comes down to, well, who if it's unreasonable, it needs to be a significant amount of money before someone's actually going to try to fight it, right?
Yeah, yeah,
Because of the time and the cost, right? Yeah, I'd have to get an attorney and then to the association, and in essence, I'm suing myself anyway. That whole thing. But ultimately, if it's a significant amount of money, where typically you run into these in the move in, move out, or resale fees,
that's
um,
exactly
that becomes
exactly hit the nail
a
right on the
bigger
head.
issue.
Yeah, you hit the nail right on the head, Patrick. That is where you see the greatest likelihood of pushback and the biggest consequences for an association in connection with pushbacks. You see a lot, the 2-month capital contribution, right, at the initial stage of occupancy. Right? Sometimes it's the first deed out from the developer, but sometimes it's a fee that's charged in connection with a transfer. But typically you see that when it's, the first deed out, they're trying to build up the reserves because maybe the developer hasn't left them with a particularly well-funded reserve. But that's where you see it kind of on the buy-in. But what you mentioned was transfer fees. So something that persists
Hmm.
and that binds a unit or a unit owner on a go forward when they're selling. And you see a transfer fee a buy-in fee, let's call it, like the original capital contribution. It's a couple of weeks. And I've seen a transfer fee anywhere from a couple of weeks to probably 6 months. The reason that, and in some associations, obviously I use the $500 example. Some associations have less, some associations have significantly more. But in either circumstance, that can be a fairly significant cost of that transaction, either buying or selling. And the question really becomes, and going back to, and this now would be in Massachusetts, but the same analysis would apply anywhere. You'd have to figure out, okay, is there a defensible basis to charge this fee? And in Massachusetts, the question would be, well, is it a payment for a common expense, in which case it has to be assessed, as provided in the statute, or is there a justification to treat this as something other than a common expense? So in this particular circumstance, you'd say, well, it's not tethered to a cost, right? You're not saying there's a cost. It really is a revenue generating device. And it's not a result of misconduct. There's nothing wrong about buying or selling a unit. I mean, you're not trying to dissuade it one way or the other. At least the board shouldn't be, right? The board should be facilitating the transactions that the owners want to engage in. It doesn't really relate to exclusive use. So that, the purpose there is revenue generating, right? We know it's clearly revenue generating, a contribution to the capital reserve on the way in, and then a a payment that is not offset by any cost on the way out. And in Massachusetts, that would be the basis that allows an association to charge the fee, because the statute says any common expense has to be assessed, has to be allocated in that particular way. The defense that the board would make to a fee like that would be, well, it's not an expense associated to overhead administration or repair, maintenance, or replacement, because it's not tethered to any cost. You just kind of admit it. It's a revenue generating fee, and the statute isn't specific in Massachusetts, but the idea is that if it's not prohibited, you can do it. We in Massachusetts and in many states now, it's a little different. It would be a little different in New Hampshire and Rhode Island, a little bit different because there is the Uniform Act in both states. In Massachusetts, we have a first generation enabling statute. What the court says basically is if it's not prohibited and it's not otherwise prevented by law, you can do it. The risk is the higher the consequences to the owner, the greater the likelihood that an owner is going to complain about it. And the potential that any one owner could say, wait a second, I'm in the exact same position as every other owner that's ever been subjected to this fee, and argue that it provides the basis for a class action. And that can have much broader significance, because now you're not just looking at the expense to one owner. You're looking at, well, in the aggregate, if it's been 50 owners or 200 owners or 400 owners over a period of time that's still within the statute of limitations, the consequences are much greater. So, you think in some respects that the topic could be mundane, but the charging of a fee can have great advantages.
Mm-hmm.
When it's big enough, it probably has the greatest advantage, but it also comes with it the greatest risk. So you do have to be thoughtful and very intentional about how you do it.
Yeah, without a doubt. It's certainly an interesting topic, and you can see that it wasn't prevalent for me, at least. I mean, I've been doing this for 20 something years as well. The fees weren't a huge topic up until maybe the last 2 or 3 years, where it just always got brought up, usually around budget season. But the resale or the transfer fee, they were very few and far between when I was working in downtown Boston. Typically, it was at the very onset, out of development, where you paid the 2 months in, and that was pretty standard. And then it's, as of recently, I've seen it more and more and more, as I kind of branched out into the suburbs in associations down in Rhode Island and on the Cape, where it was percentage of the sale, small percentage, but still a decent chunk of change, where I started thinking about, like, I wonder how big that percentage needs to be before someone starts going, what is this? Like, I haven't even stepped a foot inside the association. I'm already paying you guys, 5 figures or whatever.
Right. Yeah. Or even then on your way out, saying that you're gonna charge a fee. And I do think, going back to like advance notice, like someone who's buying in and the obligation is always already there in the governing documents, and say it's more defensible. Certainly easier to say, well, it was reasonable, or there was an acquiescence, because they decided to purchase. But if you added that policy, let's say, I bought the unit in year 1. You add the policy in year 2, and I'm selling in year 3. And I would say, well, wait a second. When I bought here, I had no understanding about this. And now I'm trying to sell, and you're literally imposing this restriction on my ability to sell without me paying that fee. I think it does change the equation a little bit. And the reason I think, Patrick, that we're seeing it more, and this is just completely subjective, but municipalities now are charging in different locations transfer fees of their own. Basically, it's like, on Martha's Vineyard, Nantucket, there's a fee associated with a conveyance that's then redirected to a particular fund that's maintained by the municipalities. Now, I don't know if there are other municipalities doing it, but it seems like since that became a thing, like, lights have started to go off with other folks who are involved in real estate transactions. And I think associations and developers in drafting their documents have thought, well, this might be another way to continue to generate revenue, after the fact. I've actually seen documents, not in Massachusetts, but documents that have provided that on the sale of each unit in perpetuity, the developer was to be paid a certain percentage of the sale price. So they create one condominium, sell it out, and you have an annuity that lasts you for or maybe even your children or your grandchildren.
Yeah. What state was that?
Yeah, 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 yeah. And
Right.
don't go there.
Right. Well, unless you're a developer.
Yeah, yeah, right, yeah.
But well, certainly, I'm sure it's not a topic that's going to go away. It's always going to be there. And like I said, every year at budget time, these questions get asked about, and a lot of it is around the investor-owned units, charging more to investor owners for move in, move out because of the administrative part that coincides with that, and making sure they're doing what they need to do as an owner of an investor unit in terms of keeping the association up to date on information and whatnot. And every year that seems to become a bigger topic. And how much can we charge? And because they want to deter that because of and I don't even know if the lending requirements I know have just changed, and I don't know what that. I don't think the owner occupancy went away, but I don't think it is as stringent as it was, where you had to maintain a certain owner occupancy in order to get lending under Fannie Mae and Freddie Mac. So, it was always a topic that needed to be discussed because, you have more and more owners selling and or buying and, renting out. It was always something that came up every budget meeting at every association, trying to get more and more fees to deter people from buying and owning or buying and renting. And that leads you to another question of like, putting in rules that you have to live in the unit for 3 years before you can actually sell or rent it as an investor, to kind of deter that as well. Is that fair or is it not fair? I guess that's always an open question. We get it all the time.
Yeah. Yeah. And I mean, the thing, I suppose it's a bit off topic, but the thing for boards to think about when they are trying to control conduct within the unit, at least in Massachusetts, is they really can't do that by rule and reg. That's something they're going to have to either find in their documents or amend their documents to include, because they'll definitely be stepping on a landmine if they're trying to do it that way.
For sure. For sure. And that's why we bring the lawyers to those meetings. So,
Yeah. You got to have
well,
somebody to throw the tomatoes at, Patrick.
all right, Tom. Well, hey, I appreciate your time always. I know you're a busy guy. I think this is a great topic to get us kind of started out here. We're going to be doing these podcasts at least once a quarter, and inviting guests like yourself on, who we consider the experts in the field, to just have a kind of open conversation about it.
Well, it's great. I think it's a great idea. And when I'm not on, I'll be watching.
All right. Well, I appreciate your time. Thanks, Tom.
All right, Patrick. Oh, anytime. Always happy. All right, take care.
That was Tom Moriarty. Great guy, kind of pillar of the industry. I've known Tom for, at least 20 years. And he's always one of my go-to guys whenever I have a question. His firm is great. There are other great firms out there. We'll have some attorneys on the show from other firms in the coming months. Appreciate everyone's time. Give us some feedback if you like this format, and we'll get the topics out about that one coming in the next few weeks. Thanks again.